Hi all, good morning to this session today. I am Parvati, handling operations for LiveLaw Academy, and today we're going to be discussing the upcoming Supreme Court clerkship examination that's going to be happening in March. We have with us a wonderful guest, Kritika Goyal. She was the All India Rank 1 in the last year's Supreme Court clerkship examination. She completed her BA LLB from the University of Delhi in 2018. She's interned under the chambers of Naveen Chawla at the High Court of Delhi, and also under the chambers of Justice Indu Malhotra at the Supreme Court. So Kritika, hi, welcome to the session.
Hi.
Firstly, can you just introduce to our audience and students today what the clerkship examination is? Thank you.
Hi, Parvati. Thank you. The clerkship examination basically is an examination which gives you the opportunity to become a clerk under a Supreme Court judge. And by a clerk, I mean, I will discuss the responsibilities and the roles of a clerk very briefly, very quickly. And it basically means that you will be assisting the Honorable Supreme Court judges of the Supreme Court with day-to-day functioning, such as making briefs, preparing case notes, researching for their judgments, and assisting in any other manner. It's usually based out of their residential office, and this exam just gives you an opportunity to work with the brightest minds, brightest legal minds in our country. So I'll start the presentation, and I'll just share my screen.
Okay, yes.
Hi, Parvati, is my screen visible?
Yes.
Okay, great. So let's just get right into it. So I'll talk about the syllabus, the sources, the material, and how to utilize them. So this exam is basically divided in two parts. There's a part 1 and a part 2. Both these parts will take place on the same day, and you will get about 1 hour of a break, one and a half hour of a break between the two exams. And so the first part will have 100 multiple choice questions, 1 mark each, and there is negative marking, which I will be talking about a little later. This exam will be of 2.5 hours. So first of all, I want to tell you all that do not worry about the time limit. There's ample time. 100 MCQs in 2.5 hours is more than enough. And now let's just get into what the questions will be. So first, there will be English comprehension based questions. For this, I will strongly suggest that if you have a good or a decent or an average grasp on English, it will be fine. It will not be a problem. You will not face any issues. You may want to attempt, or you may want to practice a few questions, but even if you don't, it will be fine. You will be able to manage. Second part will be, so I've highlighted that it deals with the ability to understand and apply law. Here I want to highlight that this is not going to be a section based exam or a bare act centric exam where they will be asking you questions in the sense of that which provision is under which section, right? And that is not going to be the way of this exam. So sorry. The questions will be strictly related to Constitution of India, CRPC, CPC, IPC, Evidence Act, and Contract Act. I want to clarify that these are the old laws, not the new laws. And you don't need to, as such, go through the new laws. I just want to point this out right here. And you can take up, so how should I put it? Okay, so these questions are not going to be bare act based where they will pick up a provision and they will ask you a section or they will ask you a particular word of that section. But they will probably just write up, give you the section there, and they would want you to apply it. I hope that all of you have gone through the sample question papers and question and answers which they've provided, which the Supreme Court has provided on its website. I really hope that you've seen it, and you can understand there that these questions are not going to test your ability to remember the provision, but your ability to understand them and apply them, just as mentioned, which is absolutely true. And next will be these objective type questions, recent development in law and jurisprudence. I will strictly tell you to focus on case laws, recent case laws, and landmark case laws. They're mostly around the case laws, and I will tell you what happened with me. So while I was preparing for this exam last year, I thought that the Delhi conflict the judgment which came around regarding the governor of Delhi and his powers and everything. I thought that this is probably political in nature and they won't ask questions about it. But that was not the case. There were about 3 to 4 questions regarding that judgment itself. So anything which is changing these 6 laws, Constitution, CRPC, CPC, IPC, evidence and contract, you need to know those judgments. And just go through the judgment. You need to understand that what was held there. When I say that you need to go through the case law, I don't mean that you have to know only the ratio, but I think you have to also look at the understanding that why this judgment was delivered, what was the reasoning behind it. Because without the reasoning, I don't think you'll be able to answer the MCQs. Because again, they are not exactly asking you what was held finally, but they want you to understand, they just want to understand whether you can follow the line of trail that a Supreme Court judge thinks on. If I can really sum that up. Okay. Next is the strategy to adopt. In the last month before the exam, this was a question which I really got. So first of all, I was asked first of all, I'm so sorry. First of all, I was asked whether how many hours we have to dedicate on this exam. So I would really suggest that do not look at your preparation in terms of hours, but I would suggest that you break down these bare acts and you break down these laws and parts into topics and you finish off the topics. So for example, if you've thought that you want to finish off Contract Act, so you pick up your bare act, you pick up the case laws, and I suggest that you pick up any repository which has all the case laws of Contract Act which have happened in the last year and all the landmark cases, and you just put it in front of you and you divide that into 3 days, maybe 3 days, 4 days, and you finish that off. And now why I'm saying this is because everybody has a different way of studying and a different way of grasping things. So don't look at it in terms of hours. You need to practice MCQs. For practicing MCQs here is, so I don't have like a book suggestion very strongly, because this is not like a judicial service examination where you have ample books and everything. But in terms of practicing MCQs, I would suggest that you look at your previous year question papers. So even though the exams which took place before 2023 were more bare act centric, but I would still suggest you to look at them and use them, those questions and those topics, to understand and identify that, okay, this is a question, this is an important provision, I should study about it. So if there is a question, let's say about conspiracy in IPC, in a past year question paper, then this should be a hint enough for you to pick up conspiracy in terms of IPC, and as it is defined under the Indian Evidence Act, look at the case laws and read about the topic holistically, right? So that you can understand everything there. Revising bare acts. Having said that bare acts are not going to be directly asked, I want to just say this, that do not skip out on the illustrations in the bare act, because those illustrations which are those provisions, they are key to understanding the application of law there. So when I say revise bare act, you pick up those sections and you revise the illustrations therein. Okay. Next, landmark cases. I can't stress enough how much studying cases, going through them is important for this exam, because ultimately also at the job with the Supreme Court judges, you will be required to be reading cases. You will be required to be researching for the cases. So you can't skip out on this. So landmark judgments, and don't overburden yourself with judgments, because I understand that when I say landmark, in Constitution, CRPC, CPC, IPC, there are, I don't know how many judgments. It's humanly impossible for you to cover them up in a span of a month, or maybe even in a span of a year. But just go through them. You should know that this is a particular case which was entailed about this. This was the logic there and everything. Okay. Latest case laws, as I was telling you, that you need to develop a reading habit and analyzing them. So one exercise which I will suggest, which you can do with latest case laws, will be that, when you read a case law, the first few paragraphs or the first few pages, they are mostly telling you about the facts of the case. So what I want you to do is that when you read a judgment or you read a case law, recent ones, you read the facts and you stop there, right? And then you just try and apply the law by yourself. and you see that what is the judgment that you're coming down to, that what do you think should be the judgment, right? That probably this is how you'll analyze and everything. And then you write it down on a piece of paper that this is what your judgment is going to be according to these facts. And then you continue reading the entire judgment. That is when you realize that how is the mind of a Supreme Court judge working when they're applying law to the facts of a case. And that will probably build a good analysis ability to analyze the situation, the facts, the law, and everything. And answer writing, I will come to that when I will be talking about part 2 of this exam. Next, let's just jump into part 2. I mean, I don't want to waste time because this was one thing that was a problem area for everyone. So this is going to be a 3.5 paper, which includes a half an hour reading time. So trust me, more than enough time. Don't worry about the time limit or anything at all. You can just divide your time into 1 hour, 1 hour, 1 hour, or you can just divide your time in the exam. I will just suggest that when you're using your reading time of 30 minutes, go to the third question first. Read the third question. You will have 5 questions there and you have to attempt only one. What I want you to do in that 30 minutes is, I mean, it's a suggestion, of course, but what you can do in the 30 minutes is that you find out which question you want to attempt out of the 5, and you draw a little, and you just write down, or you just jot a little points mentally that this is what you will be writing in that question. Okay, like a structure, like create a structure of that answer in the 30 minutes. Because anyway, the first question and the second question will have a lot of material for you to read. And I don't think that it's wise enough for you to invest those 30 minutes into reading the first question and the second question. So just spend your 30 minutes in the third question so that when you start writing that answer, you already have a framework, a structure, and you just start writing it. It will hardly take you 30 minutes to write that answer once you have a structure in your head. So now coming to the fact, in 300 marks, correct? So first question will be a brief preparation. So a brief preparation for to understand in a very usual term how it is used in the court and everything, it's called a peshi, basically. And the idea of peshi is to brief the honorable judges about what is the case at hand. So I'll tell you a little bit practically what happens. So you are given files. They can be physical files, they can be the e-files now. So you go through the file and you prepare like a very tiny synopsis of what the case is, so that it's an aid to the judges that when they're sitting on the dais or before they're preparing or they're reading the case, they can just look at the synopsis, they can look at your synopsis, read it, and they can just understand, okay, this has happened. It's like a summary, it's like a recap. Okay, because I think a judge in a day goes through more than 75 cases, more than 75 case files. And trust me, it's not humanly possible to remember every facts, every little details, but I don't know how they do it. They just do it. They're that good. The judges are that great that they do it. So you need to understand that you have to be very crisp here when you make the summary for them. And you have to understand the purpose of the summary, that while reading it, they will be able to recall it. So now just imagine that you're talking to a Supreme Court judge about a case and you're trying to brief them about it. What will you tell them? What are the things that you will not tell them? One thing you'll definitely not tell them is law. Correct? You will not tell them that this is the provision of law and it says this, it says that. They know it. They know it better than you. You don't need to tell them. You need to tell them that, listen, sir, ma'am, the facts of the case were this, very briefly, because they know, they've read the file in and out. They just want a hint, right? They just want like a one line, a few words to just trigger their memory. So you'll give them a very, just sum up the facts in not more than 2 lines, right? And then you talk about the journey that has happened. You give them a chronology of facts, that on this date this happened, on this date this happened, this date this took place, and this was ultimately the result, right? So I think you've read all of this. I don't need to go through this in detail. This was already mentioned in your scheme. I'll come here on the basic outline because this is important, because this is what you'll be writing. So you write the case number and the name of the parties on top of your answer. I think this is today we have very little time. I was just thinking about this. Maybe we can just have like a workshop later on where I can sit with you and solve the sample question papers and the previous year question papers, but I'll just go through this.
I think we can definitely facilitate something like that. If people are interested for such a workshop, please let us know in the chat and we can take that.
Yeah, we can just I'll sit with you and I'll prepare a brief and I'll prepare the part 2 of the question paper with you. So I'll just quickly run through these things. Now you write the case number and name of parties. You write the relevant facts I was saying just in 2 lines, not more than 2 lines. Trust me, not more than 2 lines. Then you write the relevant findings of the judgment and the order which are under challenge. So first of all, you need to tell them right bang on that, listen, this is the impugned judgment, this is the issue, this is what has happened, and these are the grounds. Because Purani Kahani and or the backstory, they don't need to know, right? You will mention it later on. First, they need to know what is the problem at hand, what do they need to address, right? And then you write the prayer, because you need to tell the judge that this is what they want out of you. So if you look at the first 5 points, that's just right there. This should not take up more than a page. Like, I should just tell you that when you write relevant findings of the order under the impugned judgment, you're not supposed to write more than 2 lines, like not more than 2-3 lines. You just tell them that this is what had happened, these are the facts, and this is what was held. The grounds of the challenge. Now, when you pick up the grounds of the challenge, in the petition, you'll get the petition or you get the application which is impugned and their grounds there. You have to identify only the factual grounds, not the legal grounds. Because I'm reiterating, they know the law. You don't need to tell them the law. If there is any ground which is legal, which is directly related to a law point, you do not need to reiterate that. You do not need to write it. Just figure out the factual grounds. That this is a particular ground. That's it. Write all those grounds nicely. Finish it off with a prayer. Now, any interlocutory application where necessary, I'll tell you what happens here is that why this is mentioned. So a case may be at a very different stage, right? The current point or current application may just be something else, or it may just be a continuation of delay application, or I can't think of any other examples. It can be injunction also. They may just be asking for an injunction. So you just mention that application if it is mentioned. Right now, next is a counter affidavit or a rejoinder, where there is a rejoinder or where there's a reply from a defendant. If you're getting that as well, then you mention that and you mention the grounds of those as well. Very briefly, like very, very briefly. Now, gist of previous orders is basically that in the Supreme Court, itself, when the case is going on, you may just be getting to prepare this specie or this case brief when it's the 4th hearing. So you need to inform the judges that what has happened in the previous 3 hearings. So if you are getting a previous order, then you write just a summary of that order as well. Okay, that in the first order, in the first hearing, the order was passed and this was held. This was decided in the second order, this was decided in the third, this was decided, and now this is the 4th hearing. Okay. Next is if there's an SLP, there's a delay. Of course, limitation. You need to talk about limitation. You can't do anything without a limitation, and there will always be a continuation of delay application there. You just mention in one line at the very end that so many days of delay happened in filing of the petition. That's it. That will be more than sufficient. Because again, law, you don't need to mention the law of limitation. You don't need to go through the bare act of Limitation Act. You don't need to know what Limitation Act is. You will just find that there will be a line or an application, a page. I'm sure that that page exists in a sample. Then you just mention one line that so many days of delay is there and they're seeking a condemnation of delay. That's it. Nothing more than that related to this. So now in the second question, what there is to do is a research memo. So this is a fun part. Okay, this is something that I enjoy, and this is something that you should also enjoy doing. So they'll give you a factual dispute that I'll discuss this with respect to what my previous year question was. That was a dispute related to custody of a child. Okay, so there was a dispute between the parents and the grandparents of this child that who will get the custody and everything after a divorce. The facts were something like that. And they give you relevant statutes, like complete statutes they will give you, and they'll give you case laws also. I think at least 7-8 case laws they will give you to read. And in those 7-8 case laws, there will also be some cases, there will be some cases which will be leaning towards the parents having the custody. Certain case laws will be where they will be leaning towards the grandparents having the custody, right? So you have to read through them. So now you have to understand that these judgments are huge. Why I'm telling you that you need to read the case laws is because when you get these judgments here, they'll not be the entire judgments, they will be relevant paragraphs and everything, but still you will have to go through everything. What you do is here that you go to the very end of this judgment and you try and understand in the facts and in the held part, in the ratio part, that which side it is leaning. And once you read your provisions and everything and you apply the law, you will understand that this is probably where you want to give the judgment in. Now here, you have to understand in this question is that there is no right or wrong answer. If I would have written an answer in favor of the parents having the custody, or I would have written an answer favoring the custody going to the grandparents, both are correct. Okay, what they want to understand is that your reasoning, how are you appreciating facts, how are you applying the law, and how are you going about justifying where you are giving the whom you are giving the custody to. There is no right or wrong answer to this. Okay, be very clear whoever you decide in favor of, because they're giving you both the two judgments they're giving you essentially. So you have to pick and choose the correct one. Irrelevant decisions. So sometimes when you read the judgments, like this year I was going through a lot of criminal judgments of lately, and I realized that whenever the advocates suggest a question, there's an issue and the advocates bring out judgments on which their arguments rely on, right? When you look at the structure of a judgment, what the Supreme Court judges, they do is that they pick up each and every case which is being quoted by these advocates, and they tell that why they very, very clearly write why it is not relevant, or why it is not applicable to the present case, or why it is relevant to the present case. So you need to understand that. You have to understand the thinking behind this. So the idea here is for you to identify that which judgment is relevant, why is it relevant, which judgment is irrelevant, and why is it irrelevant, and writing that very clearly. So even if one judgment is irrelevant, it does not mean that you will leave that out. It only means that you will explain it as well. That, okay, listen, this particular judgment which is mentioned, it is not relevant to the facts of the case because the facts are not similar, or the considerations are not correct, or whatever reasoning that you find. So here you have to draft like a research memo, and don't make it very long. Okay, 2-3 sides. Don't make it very long, but saying this, try and adhere to the word limit. But saying this, that if you feel that you need to write a little more, do write more. Don't restrict yourself, but it should be relevant. Don't beat around the bush. Just don't increase the length of the answer only because you think that it will fetch you more marks. No, it doesn't. Okay, everything that you write has to be relevant, because you have to understand that if you write something irrelevant, you're essentially wasting the time of a judge, right? And that is just fatal. You can't do that. You can't waste the time, right? So the parameters, you know what are there, and I'm just telling you the basic outline now. So even though you'll be given facts, but you will tell the facts, you'll write the facts again how you've analyzed them. Okay, you won't just copy paste the facts there. You will tell them that these are the facts again. So you'll again tell them the facts. You'll frame an issue which is involved, and you'll tell them that this is the law involved. You'll discuss your reasoning. This is just a structure, and follow this structure. Okay, this is a very apt structure. I followed the same structure. Don't change the structure. Like, I think I've discussed all these points, so I'll just move forward now. We can discuss this in the workshop whenever in detail. Anyway, so now this analytical question, of which I told you to prepare an outline in the first 30 minutes while you're reading. So now here you don't have to do much. 350 words to 500 words is not a lot. Trust me, it's not a lot. But there are certain tips which I want to give you for this answer. So these answers are going to be analytical in nature, right? So what do you mean by analytical in nature is that you will have to compare and contrast somewhere or the other. And if you think that the question does not demand a compare or contrast, I would definitely recommend you to rope in other statutes and rope in other provisions, or rope in any new development there and write about it. Because you cannot analyze a particular situation or a particular question without comparing or contrasting it with, and not just a difference but also similarities. So you need to understand that this is not going to be an answer which you write for your law college exams. It is just not going to be that. It is going to be that we'll discuss an example in the workshop. I'll prepare better for the workshop and I'll discuss it there. But this is only to tell you that you will have to analyze it and compare, contrast, give examples, cite case laws, and the structure is still going to be the same. That you introduce it, 2-3 lines. Probably you can start with constitution, irrespective of whichever subject that is. Just start with constitution, bring in a little bit of jurists, whatever. If you know any jurist, anything nicely said by a jurist, any line which is relevant there, you can start by that. And after that you explain what that is, and then contrast, compare, provide similar things, give an example, write case laws, and then just conclude. Okay, not this is a good structure for an answer. Okay, because they've not given a sample structure essentially. So I think this will be a good structure. Finally, I'll talk about the interview stage. So first of all, I hope you guys are aware that you will have to give out a preference list of the honorable judges once you clear the written exam. Now, a lot of you have asked me what will be the parameters of this preference list that you will give. See, at my time, all I can tell you is that first of all, preference will be that who do you want to work for, right? And first of all will be that. And second, I will suggest you that look at the tenure remaining of the judges, right? If you select one of the judges as your first preference who has only about 9 months or 1 year left in their tenure, then it doesn't make sense. Then you also do not get the scope of getting another year, right? So you can just look at who has the longest tenure, and accordingly you can choose your preferences. This was my criteria, to be honest. And I did not think about it too much, because you're not given a lot of time to think about it. Even you're given hardly a day to think about your preferences, and at that time you're just baffled. You're just too happy about your result and you're just baffled at that time. So just keep this criteria that you should get an opportunity to extend your tenure. So at least they should have 2 years of time left in this office. Okay, so the interview stage happens in 2 phases, as it happened with me. This is strictly my experience. Okay, now it may just change, but this was what happened last year. I'm basing this on that. So first of all, you will be interviewing with the honorable judges according to your preference list. They can be 2, they can be 3, they can be 4, but they will be individual. They will not be with a panel of judges. They'll be individual, right? And the questions are very it's just like a normal interaction. Okay, they just want to know about you. It's just they want to understand who you are. They want to understand what you're doing right now. And that's it. It lasts about 10 minutes, 10 to 12 minutes. And you won't even realize when it begins and it gets over. And it's just a simple question. Oh yes, I just recalled, you will also be required to send your CV after this process. Before you get your interview schedule, you'll be also required to share your CVs. So the questions will also be based on CVs. There will not be a lot of legal questions as such, but if there are legal questions, they will be based on the current knowledge, current news, current judgments. It'll mostly be based on that. And they're just testing your opinions, nothing more than that. Okay, once this happens, you will probably get an opportunity to also interview before the Honorable Supreme Court Registry. That will take place before a panel of 3 members, 3 judges, 3 members, and there you will be asked legal questions, but they will be based out of based out of Constitution, CRPC, CPC, IPC, Evidence and Contract Act. It will not be outside that. There will be the basic legal questions, just right. And I've talked about type of questions and syllabus as well. So now I just want to talk about your general guidance and approach. As you know that there is a negative marking, which is a 0.25 marks in your MCQs in the first bit. And 0.25 negative marking is not a lot, right? And I will just suggest that if you are able to boil down the answer between two options, definitely attempt that question. There are only 100 questions, attempt all. But do not attempt those questions where you have no clue at all. Like if there's a question based on legal current knowledge and you have no clue about the judgment, you have no idea whatsoever that has happened, then leave it. Otherwise, definitely take an educated guess and attempt it. Don't leave it, because if you see that if you attempt 5 questions and out of the 5 questions, even if there are 1 or 2 questions which turn out to be correct, you're in a plus, right? You won't be negative. I hope you are understanding what I'm trying to say by that. It will not impact your final score negatively, but it will only bring it up. So take educated guesses, analyze it, think about it, because you're getting a lot of time. Don't rush into it, but always follow your first instinct. Okay. And I've just shared my scores so that you have a reference point of what you should be targeting. So in the first part, I had 72.5. I think I attempted all 100 questions. I did not leave out any questions. And in part 2, so last year, we did not have the third question. Part 2, my 255 marks are only based on the first 2 questions, not on the third question. That was not part of the syllabus. So this is my score. Now, opportunities after this exam. So first of all, I want to tell you that if you are planning to give the AOR exam and become an AOR, this is a very good opportunity, because the 1 year or the time that you will be working with the judges, that will be counted towards your practice for AOR. So that's a golden opportunity. You get best of both worlds, basically. And you can definitely try for judicial service examinations. A lot of people that I know are actually aspirants who give this exam. And you can definitely go for litigation, because you will get a lot of connects. You'll talk to a lot of people. You'll understand the application of law and everything very nicely. So you won't have that issue. Even if you're a first generation lawyer, you will make ample connects and everything. I'm a first generation advocate, so you will make ample connects and everything in terms of going into litigation or even corporate law. You definitely can do LLM from India or abroad, because you get a shining letter of recommendation from probably the highest authority in India. There can be, and others I have written, because see, once you get the opportunity to work for the Supreme Court judges, your mind gets really polished and you get really, really trained, and you're able to just take on to any opportunity, any difficulty, anything with utmost grace, right? Your thought process becomes like that. You're accustomed to handling stress. You're accustomed to not taking a lot of leaves. You're accustomed to being responsible, right? So you develop personally and professionally a lot. So anything else, anything under the sun is possible. Hi, Parvati, maybe we can start with the question and answer.
Yes. Thank you so much. I mean, I wanted to, I thought we'd ask questions, but then you had such a great flow. I didn't want to interrupt. That was a wonderful session. You covered almost everything I think the students wanted to ask. Definitely, I'm just going through the chat questions right now. So the people who are watching, I think around 100 people are watching. If anybody has any questions, please raise it right now and I can ask that directly. But there are some questions already. One is if there are any books to prepare for the exam. I think you've already answered that there's no concrete one source. Yeah.
Like, just don't restrict yourself to books. I'll always suggest that whenever you're preparing law, it's always best to pick up a landmark judgment. You will get more theory and more application there in any book that you will find. And that will be relevant, In books, you sometimes find something which is irrelevant. or which is too high a level, which you don't need.
Absolutely, absolutely. I think they've asked about what is the overall experience of a law clerk at the Supreme Court. So I think you've already detailed what their duties will be, but if you can just tell them what you think would be their day-to-day responsibilities once more since a question has been asked.
Okay, so you'll be required to brief the judges. You'll be required to research for them for their reserved judgments. You will be required to prepare briefs. So basically, whatever you're doing in the part 2 of this exam, that's exactly what you'll be doing in the office. There is,
yes.
I can't stress that enough. It's a very practical paper. That's exactly what you're doing, and you're just there in the presence. You're discussing law with the best minds. That's what you're doing.
So yes, and there's a lot of interest for the workshop. So I think maybe sometime in the next weekend, if we can
Definitely.
have like a longer session with just all, and we can maybe pre-release a question paper, potential question paper on our website, and then we can have the students answer it from their end, and we can discuss the model answer from your end as well. We can try something like that next weekend, since there's a lot of interest for that. There's another question is, where can we find the previous year question papers? I believe that's available on the
Supreme Court website.
On the Supreme Court website. Yes. So that was one question. There's another question. Are all of those 5 questions related to constitutional law?
Not necessary. Not necessary. But I would suggest that you prepare the constitution well, because if they've given questions of constitution in the sample, you can definitely expect at least constitution questions in the paper.
Yes. Then will there be 2 questions, one with the judge and another with the registry? I think the question is, will there be 2 interviews? Probably.
So if you get placed with any of the Supreme Court judges, then you may not have an interview with the Supreme Court registry. But if you don't, then you will definitely probably get that opportunity to interview before the registry as well.
Yes. In the third question, how to deal with the synopsis and brief part in the part 2 paper?
Okay, so I think I've discussed that at length, and I can probably just take that up as a workshop. I think that will make more sense, because
I think
have an example.
Yes.
If I'll have an example, I can just prepare it right there with you live. That'll just give you an idea.
Yes. How much time is there between the result being published and the interview part?
Okay, so the result, see, this is going to be a long process. I'll be very honest. It requires a lot of patience, and at least 2 months. No, the result and the interview is not going to take a long time. I'm sorry. The exam and the result will take it may take a long time, because they're also evaluating your written questions. But from the result, I think a week or 2 weeks, not more than that.
Right. So I think since this year the exam is bound to happen in March. I think last year it was in May, but this year it's happening in March. So everything should happen by, I think, June, July. By the time the summer holidays.
Absolutely. They would want to do that then.
Yeah, I think that is
their assessment will definitely begin from the. See, one thing I'm pretty sure of, that the clerks who are placed right now with the Supreme Court registry, we have our contracts till the court picks up for the summer vacations. So post summer vacations, they would definitely be hiring new ones. So I think you can expect it to be covered up by then. Yes.
Another question is how to prepare for the reading comprehension parts. Like, is there any particular? I think just something like LiveLaw, honestly, I think would be could be.
Absolutely.
I think any place with a lot of judgments where you can
any place with a lot of judgments, you get a repository of judgments where you can just search for Contract Act, and you can get good amount of judgments of that. Reading comprehension also for English, you can just pick up any book, any English book. It's going to be very basic. Don't be intimidated by that, right? Don't worry about English. Once you'll be reading those judgments, so many judgments, your English will improve. Don't worry.
Right. I think another question that we have is how to prepare, because since judgments are latest and recent, there are no particular books. So how do you get a consolidated idea of where to exactly how to find all of these judgments is a question that somebody has asked.
Okay, so I know for a fact that the Supreme Court website is also they've also uploaded all the judgments on their website, but you'll have to search and put all the filters and everything. if you think that you can do that, you can probably get your judgments there. But as Parvati was saying, LiveLaw is also a good platform where you can just get like a consolidation of judgments, or any other platform where you can
follow the digest. I think that should be
absolutely easy. Absolutely. Yes. That would be very convenient.
Yes. Is there any cutoff for the particular exam? Is there a cutoff based examination?
See, it is sort of a cutoff based examination, but I can't recall what was the cutoff last year, or if I even thought of it, but I'll research and I'll let you know soon about the cutoff. But there will be a cutoff, because I think a lot of students appeared, and the written exam result, only 250 students had their name in the PDF. So there'll definitely be a cutoff. At least minimum marks are there. That's what I know.
There are some questions on what would be the expected cutoffs, but I think that's a question you can only answer when you see the question paper. Yeah. So, yeah. True. Again, when you say contract law, does it include sales of goods, partnership act, specific relief, everything?
No. Just the contract act. Just the contract act.
Okay. And I
can just say one thing about the cutoff. Everybody who's asking me for a cutoff, please don't target the cutoff. Target the topper's marks, which is why I shared my marks with you. Don't target the cutoff. Target the highest possible marks. I would suggest that you cross my marks as well. Your target should be that. Your target shouldn't just be restricted to a cutoff. I'd really strongly suggest that.
Yes. There was another question: should we read the new criminal laws or the previous one? I think it already answered that the focus will more be on the actual previous criminal laws that were there.
Yes. Factually, you can just look at things which are related to the new laws, but don't go through them. Don't waste your time there. Because if they are relevant, they will be reproduced in the question, in the paper. Don't worry. There are multiple times where they just reproduce the provision as is. So don't worry about that.
Right. I think it's more about interpretation rather than
absolutely. I mean, if you have to focus on the illustrations rather than the provision. I mean, just read the provision, focus on illustrations.
Definitely. Can you tell us the weightage split for the subjects in the exam? The 6 subjects that you'd mentioned. Is there a weightage split?
They have equal weightage. As far as I can recall, they all have 20 questions at least. As far as I can remember, 20 questions from each. Each section has something like that, yeah.
There's another question on, is there any place where we can practice the brief making? I don't think there's a particular place, but if you can log in for a workshop that we'll be having next week, then we can have a brief making session practice.
Yeah, what we can do is we can solve the sample questions, and we can solve the previous year questions. We can solve 2 questions there.
So I'll try to put up a post on LiveLaw regarding all of this. And for those of you who are watching, we'll put the previous year question paper as well as the model structure. And so that you can create it on your end and we can have a workshop and discuss what can be done better. So that is there. And can you share? I think we already discussed the strategy. There was a question on the strategy. If you could just watch the live from the starting again, the second topic was the strategy. And is there any particular timeline, like for you particularly, was there a specific, like 3 months may you cracked the exam? Is there any timeline that you completely devoted to this?
Not really, to be honest, not really.
Right. I think it's a long process that
it's a process that you develop from the first day you step into law college. I mean, I'm from Delhi University, and we've just been in the habit of studying the case laws from the very first day. So I think it's just that. How much ever longer it takes for you to cover case laws, as many as possible, that will be your timeline, I think.
Yes. So I think that's all, Kritika. Thank you so much. I've answered. And we look forward to having a workshop on this sometime next weekend.
Thank you so much
for
joining.
Yes, thank
all
you
the
so
best.
much. Bye.